seminar is find out if any of you have been in one of my seminars in the past. Okay, a couple of them, 4 or 5. What I'd like to do is ask just a general question of all of you and see if it start a little bit of participation. Remember, if you have a question, probably somebody else has the same type of question, and that really is the best way to flesh out some of the issues that you may be thinking about, separate from what I might talk about. I will stay on tune to a certain degree with the written materials, but maybe not in the same order that they're presented there in the materials. But I'm going to just ask generally what you might think happens to your property if you don't have a will. If you don't volunteer, I will call on you. So
I would guess that it goes to your spouse.
Goes to your spouse? Okay. Anybody else? You got one that goes to your spouse?
Has to be probated.
Goes up to the probate court? That's another answer. Anybody else? You said it goes to your spouse. What makes you say that?
Well, again, that's like, well, in Ohio, there's a law that your spouses.
You're right. You're on the right track. I'll help you out a little bit. There is a law in Ohio. It's called the Statute of Descent and Distribution, and it controls where your property goes if you don't have a will. Unfortunately, it doesn't necessarily go to your spouse. The statute is amended periodically in Ohio, and unfortunately, they amend it, it seems like about every 5 or 6 years, something like that. And the statute is actually in your materials there, and you'll see it if you find it in the materials. It's very complicated. And it depends on whether you have both of the spouse and the deceased are natural parents of all of the children. If they're not, and it splits up, and sometimes it goes on down to the children. Sometimes the first $60,000 goes to the spouse, and the rest of it goes to the children, and 50% or a third shares or whatever. So it doesn't necessarily go where you want your property to go. So I think most of you would agree that that might be a good reason to make a will, to make sure that your property is going to go where you want it to go. Can somebody else think of another reason why you might want to make a will?
Avoid probate.
Avoid probate? Usually you're not going to avoid probate with a will. We'll talk about some other techniques that will avoid probate for you. Think in terms of if you want to, if you have to, in selling your estate, sometimes you have to sell property. What happens if you don't have a will? Well, again, there are specific statutes and laws in Ohio that control that situation, but it's usually very complicated, and you're going to have to seek court approval to do it and sell the property. So what can we do in a will? We can flex up all of that concept for you and make it very easy for the person winding up the estate to sell the real estate or sell the personal property and decide what you're doing. How many of you have, and this might be but how many of you have minor children? Oh, okay. Can you think of a reason why you might want to make a will because you have minor children? Rhonda?
Or guardianship of the children.
Exactly right. She said guardianship of the children. If you have to think ahead when you're thinking about the situations when you have a will or when you have estate planning, and there's always the possibility that you may be killed simultaneously or within a very short time. You may be involved in a car accident, for instance. A gentleman here and I were talking earlier about that. And both of you may be killed, and you may have minor children. And I'm assuming that if that's the situation, that you want to make sure who's going to take care of those children. A very, very important reason for younger people to make a will. Which brings me back to another question. Is it only people my age, and I'm 60. Is it only people my age and older that should be making a will? And why not? Again, because of possibly the testament. Is there other reasons that you might want to make a will?
Well, I don't have a spouse, but I have grown children, so I want them to get it, I guess, instead of the state to get it.
Right. Yeah, that's a very good answer. I'll paraphrase her, work around what she's saying. What she's really saying is, you got to look beyond just immediate, who's going to get my property. We have to consider we all have children, we have other people, so we want to make sure that our property passes beyond maybe a distant spouse to our children or our grandchildren. So that's another good reason, because it's not necessarily what's going to happen under the statute of simple distribution in that situation. There's another good reason why people sometimes consider making wills. Do any of you have children or know of children with special needs?
Yeah, my son, that's why I'm here. I don't know if I need to get a will or a trust or something set up for him. Should someone take care of him if something should happen to me?
Right. That's one of the primary, and you can do it both in a will, and we can do it in a trust, or you can do it with a trust or a will. There's several different ways we can handle that situation. It all ends up being kind of tailored to what your specific situations are, which is kind of another reason why you may want to consider making a will, because I doubt that any two of you here have exactly the same situation in life. If you did, it would be unusual. And when I meet with you and talk to you about, say, thing, what you want to do in your will, it really is my listening first to what your concerns are, what you want to accomplish, and then we talk about how we can accomplish that in a will. How many of you think that once you make a will, it's in effect immediately and it's a done deal? I got one here. Anybody else? Got 3, 4?
I thought you signed it and it's done.
You just sign it as done.
We're good.
The answer to that, unfortunately, is not necessarily. A will is a document that's only in effect, only becomes effective at the date of your time of your death. So it has no current effect at all when you execute a will. It's a document that takes effect when you die, which allows you the flexibility of changing that document any number of times until you die. Now, you don't really want to have to think about what's going in your will every year or every 2 years. So what we try to do is do at least a 2-step distribution in your will, and sometimes a third step distribution in your will, so that you take care of these situations unless you have some life-changing event, and sometimes that happens. You don't plan on that extra child that has cerebral palsy or something like that, and you have to take care of them. So those are some of the reasons why it's wise to make a will. Those are reasons why you may want to consider making a will at various stages of your life.